construction on I-75, and has slowed them down, so I don't know where they are at this moment. We're waiting for weed. There's some construction. This is
Or we can talk about jury instructions for a little while they
right.
go lunch.
All right, let's do that, and maybe you'll be here then. There's construction on I-75, and he's slowed them down. All right, so let's break for an early lunch, and we can be working on instructions in the meantime.
Okay.
All right. Okay.
Yes, that's great to me.
And then we can modify them after we hear the final witness.
For permission
if necessary.
to get some food for the attorneys brought up here. I mean, we'll pay for it, but or I'll even send people out to get it. But it takes 45 minutes to go get it back in, and then we can't bring it up from downstairs unless we go out the gate.
I can go get whatever I want. I'll go out and
You just want to be able to bring it up here and eat?
Yeah, I mean, just
Well, you can do that if you want to.
Yeah, okay.
I can go get whatever y'all want.
Okay. I
If
appreciate
I
it.
go get me and him.
Yeah, just get it on together. She runs out. Chrissy runs out and
We
gets
could
me
give
something.
them a 2-hour lunch break, so we have some time to work on jury instructions, and get our witness here.
Yeah,
They'll
well,
appreciate it.
We're going to take a full 2 hours?
Well, I mean,
I don't think we may not take that time, but
Okay.
it doesn't
I'll
hurt
let
to
them
give
go
the
for
jury
2
that time.
hours. And then we need to make sure Weedman gets back here, and we can be working on
that
instructions
gives
in the
us till 1
meantime.
o'clock, and then if they're,
Okay.
that's their last witness, how long do y'all anticipate them being?
10 minutes.
Yeah, like
Okay.
that.
How
That
long?
kind of short.
And then we're in
like Mr.
closing.
Powers, that level of
minutes, and
short.
then
And
they're not
then we
jumping
can give it to the
testifies.
jury and let them have it as long as possible, but I will be prepared, and I'm gonna ask if they are still deliberating, that we order pizza and we stay here as long
Oh,
as
we
we
will.
can.
We will.
Yeah,
All right.
love pizza.
Exactly.
Me too. Good health food. I like it. All right. Okay. All right, ladies and gentlemen, there's one more witness. Unfortunately, there's construction on I-75, and it's slowed up right now. So I'm going to let you go for an early lunch and be back you have 2 hours for lunch. That's all you can eat for a long time, and be back at 1. And then it looks like that's when we're going to wrap it up with this last witness. All right. So. Same admonition, of course, don't form any opinions, don't talk to anyone, don't talk among yourselves, and report back to me if anyone approaches you. All rise for the jury. All right, we're back on the record this afternoon in the Commonwealth v. Shelby, Shell, 13 CR 00076, Harlan Circuit Court. Mr. Shell is at the bench right now. If you have a statement.
If you remember, we actually talked about
Wait.
it in 1 year.
No, it's up for
And we talked about the right to not testify and the right to remain silent in 1 year.
Absolutely.
And we reserved that option until our case, just in case Mr. Shell changed his mind. But we've talked to him about the case, and we've gone over kind of the evidence presented and what's going on. And I think right now he's taken the option to remain silent, which is his constitutional right.
Is that correct, Mr. Shell?
Yes, sir.
Thank you, Mr. Shell. All right, very good. Well, let's get on with business then. If you can have a seat there, Mr. Shell.
The record will address the defense had intended to call one more witness, but because he's been advised of his Fifth Amendment right, we're not going to call him.
That's fine.
So we'll be
Okay. All right. Well, let's go. All right, we need to call the jury in, please. All right, all rise, Jury, please. Be seated, please. Is there anything to report back to me, folks? All right. I hope everybody had a good lunch. All right. Okay, we're still in defense's case in chief. Where are we at this point? Where are we at this
At this
point?
time, the defense rests, Joe.
The defense rests. All right. Is there any rebuttal by the Commonwealth?
No, Your Honor.
All right, then that closes the evidence in this case, ladies and gentlemen. You're going to get a little bit of exercise at this point. I'm going to let you go out again and have another break, and I'll tell you why. We're through with evidence, and so at this point we'll have some motions. Brief motions out of your presence, and then we're going to prepare instructions and bring you back in here, and you're going to get the case presented to you. All right. So I'm going to ask you to please step out again, and same admonition as before. Still, don't make up your minds about anything. Leave your notepads there in your chairs and all that, and don't talk about it among yourselves. And report back to me if there's any abnormalities. So all rise for the jury. Okay. All right. Be seated, folks. All right. We're at this juncture in the case. Does the defense have any matters to bring up at this point?
The defense renews the earlier motions for directed verdict at this time.
Okay.
I don't know that I need to repeat the grounds at this stage.
It's advisable.
It's advisable. So, let me include all of the grounds previously mentioned.
Well, I think I remember the grounds previously made, and again, it's the same standard for directed verdict. We indulge all evidentiary inferences in favor of the Commonwealth, in favor of the non-moving party. I should put it that way. At this juncture, the motion the only thing that I had a question about earlier was burglary, but as I understand the statute, it's I'm still a little I need some advice on that and where we stand on that, because it says entering or remaining in a residence or dwelling without consent. Do you have any argument on that particular issue?
I do, and there's another side issue I'll add to that argument. So, if the court believes or has to believe the testimony of Ernie Shell and Jim, if you have to believe Ernie Shell and Jimbo Collins at this stage of the proceeding,
I really can't hear you. I'm sorry.
Can I stand at the podium?
Yes, please do. Please do.
If you have to take what the Commonwealth's witnesses said is true at this stage of the proceeding for the directed
I do,
verdict,
yeah. I have
then
to.
Ernie Shell and Jimbo Collins stated that Shelby gained entry by pretending to be Kevin and then offered to perform a sex act and then maybe offered to sell Mr. King a gun. So to the extent that Mr. King did not immediately, upon seeing Shelby instead of Kevin, kick him out of his home or struggle or call police, it appears that there was at least consent for entry at that point. Consent maybe by subterfuge, but consent. So that's why we would make a motion for directed verdict on the burglary first charge.
My concern is not.
There are, for example,
It's
sorry.
not the entry; it's the remaining.
Right.
I'm not sure about the standard on that. About can they draw an inference from other events that was going? Can the jury draw an inference from the events that were going on otherwise in the house, as the evidence has shown or has tended to show that it was without consent to remain there.
And I'll give an example from a burglary third argument, which is somebody might go into Walmart and there's a general consent to the public to come in and shop, but when they become a shoplifter, they haven't committed burglary at that point. They've committed a crime while they were in a place where they had permission to be. Now, if they came back later and Walmart said you're banned from shoplifting, like there have been charges of burglary related to that. This is that type of situation where he, based on the testimony of the Commonwealth witnesses, had the right to be in the place where he was granted access by Mr. King, although he later committed a crime, and certainly would not be granted permission to come back there after that.
Ms. Lee, do you have any response to that? We'll take one subject at a time.
Yes,
Yeah.
I've got several responses. So first of all, consent never occurred. Shelby Shell is not Kevin. The evidence of this case shows that Shelby Shell entered Ronnie King's house by stating, "I'm Kevin." Once in there, the evidence shows that it was an extremely uncomfortable situation, and wherein at some point Shelby Shell removes a firearm. At that point in time, after having gained access by stating that he was Kevin, Ronnie, the victim, Ronnie King, begins to say, "Whatever. I'll do whatever. I'll do whatever," because Shelby Shell has a firearm and is threatening the man. At one point, testimony from the phone call is that he says, "No, Shelby, we're not doing that right now," insinuating to leave. Shelby does not leave and begins to duct tape him, bind him with zip ties, bind him with a belt, do a whole host of other things, and then shoots him in the head. But that's not it. He remains even after that. I mean, Ronnie King can't
I understand all that. Here's my more specific concern: is that there's really no evidence that he entered without consent. The Commonwealth hasn't proven that he entered without consent. That burden of proof is on the Commonwealth beyond a reasonable doubt.
I think we proved that he entered by stating he was Kevin.
It doesn't, but there's no evidence that he wasn't let in anyway.
And then when the altercations began.
Now, my concern is the remaining, and it says enter or remaining.
Let me ask the court this, Judge.
Let me ask you. My question is: can the jury infer from subsequent events inside the house that is that sufficient to give to the jury on remaining?
Absolutely, it is.
That's what I'm trying to come to terms with.
And the point that I would make more than that, absolutely it is, yes, Judge. But more than that, once Ronnie King is killed, the evidence shows that Shelby Shell remained left, and then what did he do? He came back. The evidence says he came back.
We're getting beyond it. I'm focusing on remaining, and the evidence does the surrounding evidence after he's in the house. After the evidence of him being in the house is presented, do those subsequent circumstances, is that sufficient to submit it to the jury on remaining?
I would say yes, Your Honor.
That's what I want to know.
Yes. However, my argument would not stop there, because if the court can recall, the evidence that the Commonwealth has submitted is that Shelby Shell got in by Kevin. I'm not making that argument now.
killed Ronnie King, left, and then, as he told two individuals and himself recorded, came back to set a fire to destroy evidence.
I see. Okay.
He
I
couldn't
see.
get permission at that point because he'd already killed Ronnie King.
All right, I see what you're saying. All right, okay. All right, okay. What about any arguments on the other counts?
On the kidnapping, we would renew our motion that actually this falls into the exemption, that there was no kidnapping in addition to other crimes. There was never a purpose for kidnapping. The purpose, as alleged by the Commonwealth's witnesses, was murder. So the only restraint that occurred was the restraint required for the force to commit the murder. There was no additional restraint to commit a kidnapping.
I
So
think
that's
the underlying purpose
there.
from the evidence that is pretty strong that the underlying purpose was to get was a financial gain one way or another, and under Stanford v. Commonwealth 793 Southwest 2nd 112, murder is the ultimate restraint. So the kidnapping exemption does not apply.
Thank you, Your Honor.
All right, so motion from Director Burke's overruled. We need to take a break now or go back here and we need to get some instructions together. I have one copy from the Commonwealth I'm going through. I'd like to see what the defense has to offer pretty soon.
Ms. Karen, did you
Okay.
get those from us?
Can we go back to?
And I'll say
Yeah,
that
that's
murder
that's
is
either a first
well beyond the interference
They didn't
necessary
want
to
make corrections.
burglarize or Okay. Council will give you a copy, we got them done, ready.
I don't have a copy yet.
I'm gonna give them to you.
Okay.
Bring 'em up. If you give that one. All right. Get the defendant out here. Oh, there he is. We need to bring the jury in.
Before we do that, I have 2 or 3.
Well, you want to tender, you wanted to tender some instructions and
Right,
for
just
the
for the
record.
record,
Right.
the Commonwealth has objected to these, and the court has, I guess, sustained their objection.
The two theft instructions and one having to do with intellectual disability, and I'm overruling the intellectual disability, and I'm overruling the two theft instructions because the evidence simply shows nothing more than it doesn't go to theft. It simply is robbery or nothing. Yeah.
Thank you.
All right. So let's put those in the record as tentative instructions by the defense. Now we're ready to get the jury in here.
Bring jury in.
If they're still here. Oh, well, Yeah, have anything to report, ladies and gentlemen? No. Okay, very good. All right, be seated, please. We're at the, getting ready to give you the instructions and closing. Have our closing arguments. I'll ask the bailiff, hand these out to the jury. So you can all read along as I read you the instructions. Yeah. Okay. Is there anything else before I read the jury the instructions? All right. All right. Let's let all the copies get handed out so you can read along with me, and then we'll leave one copy with. I don't know, one copy to take back into the jury room with you, because they had the copy that has the verdict forms on it. But I want you to have a copy that you can read along with me while I'm going through these, so I think that's helpful. I'll sign the copy that you take back, and which I'm going to choose a form for a person. All right, does everyone have those? Okay. Starting on page 1, these are the instructions to the jury for this phase of the trial. And, excuse me. Instruction number 1, reasonable doubt and presumption of innocence. The law presumes the defendant to be innocent of a crime, and the indictment shall not be considered as evidence or having any weight against him. You shall find the defendant not guilty unless you are satisfied from the evidence alone and beyond a reasonable doubt that he is guilty. If upon the whole case you have a reasonable doubt that he is guilty, you shall find him not guilty. Instruction number 2, the right to remain silent. Every citizen charged with a crime has the right to remain silent at trial, including the sentencing hearing. This is because it is not the citizen's responsibility to prove that he is innocent of any crime. The law presumes the defendant to be innocent of a crime, and the indictment should not be considered as evidence or having any weight against him. The defendant is not required to testify, it says in this phase, or in any, as is his right. You shall not draw any inference of the appropriate punishment. Excuse me, that shouldn't even be in there. You should not draw any inference from, and I'm penciling this in, defendants not testify. It's his constitutional right to remain silent. And you shall not allow his choice to prejudice him in any way. Instruction number 3, unanimous verdict. The verdict of the jury must be in writing, must be unanimous, and must be signed by one of you as a foreperson. You may use one of the forms. You shall use one of the forms provided at the end of these instructions. Now, that's a misstatement too. The verdict form is after each instruction, each substantive instruction, and we'll walk through that and you'll see it as we go through. Instruction number 4, these are definitions of certain terms that are in the various instructions. These are statutory definitions of what some of these words mean. Intentionally, a person acts intentionally with respect to a result or to conduct when his conscious objective is to cause that result or to engage in that conduct. Physical evidence means any article, object, document, record, or other thing of physical substance. Official proceeding means a proceeding heard before any legislative, judicial, administrative, or other governmental agency or official authorized to hear evidence under oath, including any referee, hearing examiner, commissioner, notary, or other person taking testimony or depositions in such proceedings. Deadly weapon means any weapon from which a shot readily capable of producing death or other serious physical injury may be discharged, including any such weapon that is unloaded or incapable of discharging, so long as it otherwise belongs to a class of weapons satisfying the meaning of a deadly weapon. Physical force means force used upon or directed toward the body of another person. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious and prolonged disfigurement, prolonged impairment of health, or prolonged loss or impairment of the function of any bodily organ, or death. Restrain means to restrict another person's movements in such a manner as to cause a substantial interference with his liberty by moving him from one place to another, or by confining him either in the place where the restriction commences or in any place to which he has been moved without consent. A person is moved or confined without consent when the movement or confinement is accomplished by physical force, intimidation or deception, or by any means, including acquiescence of a victim. If he is under the age of 16 years or substantially incapable of appraising or controlling his own behavior, that last part would not apply to this case. That's just a statutory definition. Building, in addition to its ordinary meaning, means any structure, vehicle, watercraft, or aircraft where a person lives. B, where people assemble for purposes of business, government, education, religion, entertainment, or public transportation. Each unit of a building consists of 2 or more units separately secured or occupied as a separate building. Dangerous instrument means any instrument, including parts of the human body, when a serious physical injury is a direct result of the use of part of that human body, article or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing death or serious physical injury. Physical injury means substantial physical pain or any impairment of physical condition. Wantonly, a person acts wantonly with respect to a result or to a circumstance when he is aware of and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstance exists. The risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. There's a bracketed insert there about intoxication, which does not apply to this case, so I'm striking that, and this will be the copy that I will be giving you to consider. Knowingly. A person acts knowingly with respect to conduct or to a circumstance when he is aware that his conduct is of that nature or that the circumstance exists. Possession means to have actual physical possession or otherwise to exercise actual dominion or control over a tangible object. Handgun means any pistol or revolver or any other firearm originally designed to be fired by the use of a single hand. Now, instruction number 6. Murder, a capital offense, count 1. You will find the defendant guilty of murder, a capital offense, if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in Harlan County, Kentucky, on or about the 17th day of February 2013, and before the finding of the indictment herein, Shelby L. Shell killed Ronnie King by shooting him. And B, that in so doing, Shelby L. Shell caused the death of Ronnie King intentionally. And C, that he did not act in self-protection. The next page is the verdict form. When I read this in the beginning, it said at the end of the instructions, but the verdict forms for your convenience follow each count. So it begins at the top, and with regard to this instruction number 6. We, the jury, agree by unanimous vote that Shelby L. Shell is not guilty of murder, a capital offense, under instruction number 6. Drop down, and there's a place for the foreperson to sign that, and all of your determinations in this matter have to be unanimous. Halfway down the page, next it says, we the jury agree by unanimous vote that Shelby L. Shell is guilty of murder, a capital offense under instruction number 6. Again, a line for the foreperson to sign. Then you'll see below this, if you do not find the defendant guilty under instruction number 6, then you shall proceed to instruction number 7. However, if you find him guilty under this instruction number 6, then you shall skip instruction number 7. And it will always say on the bottom of the page, for personal assignment, only one verdict on this page. So, instruction number 7 is the following page. First-degree manslaughter. If you do not find the defendant guilty of murder under instruction number 6, you will find the defendant guilty of first-degree manslaughter under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. That in Harlan County, on or about February 17, 2013, and before the finding of the indictment herein, he killed Ronnie King by shooting him. And that in doing so, he did not intend to kill Ronnie King, but intended to cause serious physical injury to Ronnie King. And that he was not privileged to act in self-protection. Though otherwise privileged to act in self-protection, the defendant was mistaken in his belief, that he was not privileged to act in self-protection, or, though otherwise privileged to act in self-protection, the defendant was mistaken in his belief that it was necessary to use physical force against Ronnie King in self-protection, or in his belief in the degree of force to protect himself, and when the defendant that "and" should be stricken, I think. That it was necessary, I'm going to start D all over again. Though otherwise privileged to act in self-protection, the defendant was mistaken in his belief that it was necessary to use physical force against Ronnie King in self-protection, or in his belief in the degree of force necessary to protect himself when the defendant caused serious physical injury to Ronnie King. The "and" does stay in there, my fault. He was aware of and consciously disregarded a substantial and unjustifiable risk, that he was mistaken in that belief, and that his disregard of that risk constitutes a gross deviation from the standard of care that a reasonable person would have observed in the same situation. Next page again is the verdict form. We, the jury, agree by unanimous vote that Shelby L. Shell is not guilty of first-degree manslaughter under instruction number 7. The second option, the only other option, we, the jury, agree by unanimous vote that Shelby L. Shell is guilty of first-degree manslaughter under instruction number 7. Again, it doesn't say it on here, but that 4 persons should only sign what's on that page. Instruction number 8, tampering with physical evidence, count 2. You will find the defendant guilty of tampering with physical evidence if and only if you believe from the evidence beyond a reasonable doubt all of the following. That in Harlan County, Kentucky, on or about the 17th day of February 2013, and before the filing of the indictment herein, Shelby L. Shell altered, concealed, or removed evidence which he believed was about to be produced or used in an official proceeding by a B, setting fire to the house in an attempt to destroy evidence of a crime, and that he did so with the intent to impair its accuracy or availability in the proceeding. If you find the defendant guilty under this instruction, you will state in your verdict only that you find him guilty. That gets stricken. It takes a long time to do these instructions, and a lot of artifacts get left in there that don't belong in there. I'm marking this out on the copy that's going to be given to you to take back. That's this bottom paragraph that I'm marking out. Next page will be the verdict form. We, the jury, agree by unanimous vote that Shelby L. Shell is not guilty of tampering with physical evidence under instruction number 8. The next choice, we, the jury, agree by unanimous vote that Shelby L. Shell is guilty of tampering with physical evidence under instruction number 8. Again, there's only 2 options, and the 4th person shall only sign one of them. Instruction number 9, robbery in the first degree, count 3. You will find the defendant guilty of robbery in the first degree if and only if you believe from the evidence beyond a reasonable doubt all of the following. That in Harlan County, Kentucky, on or about the 17th day of February 2013, and before the finding of the indictment herein, Shelby L. Shell stole jewelry and money and other items from Ronnie King, identified as Commonwealth's Exhibit 9. And that in the course of so doing, and with intent to accomplish the theft, Shelby L. Shell used or threatened the immediate use of physical force upon Ronnie King, and that when Shelby L. Shell did so, he, Shell, was armed with a pistol. And D, the pistol is defined as a deadly weapon under instruction number 4, which were the definitional instructions. Verdict forms on the following page. We, the jury, by unanimous vote, agree by unanimous vote that Shelby L. Shell is not guilty of robbery in the first degree under instruction number 9. Second option, we, the jury, agree by unanimous vote that Shelby L. Shell is guilty of robbery in the first degree under instruction number 9. Instruction number 10, next page. Kidnapping, a capital offense, count 4. You will find the defendant guilty of kidnapping if and only if you believe from the evidence beyond a reasonable doubt all of the following: that in Harlan County, Kentucky, on or about the 17th day of February 2013 and before the finding of the indictment herein, Shelby L. Shell restrained Ronnie King by wrapping zip ties to the hands of Ronnie King, or by wrapping duct tape around the hands of Ronnie King, or by wrapping duct tape around the head of Ronnie King, and that the restraint was without Ronnie King's consent, and that in so restraining Ronnie King, it was Shelby L. Shell's intention to accomplish or advance the commission of a felony, and that Ronnie King suffered a serious physical injury during the kidnapping. Next page is the jury form. We, the jury, agree by unanimous vote that Shelby L. Shell is not guilty of kidnapping, a capital offense, under instruction number 10. Next option, we, the jury, agree by unanimous vote that Shelby L. Shell is guilty of kidnapping, a capital offense, under instruction number 10. Again, with lines for 4 persons to sign one of those decisions. Instruction number 11, burglary in the first degree, count 5. You will find the defendant guilty of burglary in the first degree if and only if you believe from the evidence beyond a reasonable doubt all of the following: that in Harlan County, Kentucky, on or about the 17th day of February 2013 and before the finding of the indictment herein, Shelby L. Shell knowingly entered or remained in a building owned by Ronnie King without the permission of Ronnie King or any other person authorized to give such permission. That in doing so, Shelby L. Shell knew he did not have such permission. C, that Shelby L. Shell did so with the intention of committing a crime therein, and D, that when effecting entry or while in the building, Shelby L. Shell was armed with a pistol defined as a deadly weapon under instruction number 4. Next page is the verdict form. Again, we, the jury, by unanimous vote, find that Shelby L. Shell is not guilty of burglary in the first degree, or we, the jury, agree by unanimous vote that Shelby L. Shell is guilty of burglary in the first degree under instruction number 11. Next page, instruction number 12, arson in the second degree, count 6. You will find the defendant guilty of arson in the second degree if and only if you believe from the evidence beyond a reasonable doubt all of the following: A, that in Harlan County, Kentucky, on or about the 17th day of February 2013 and before the finding of the indictment herein, Shelby L. Shell damaged a building owned by Ronnie King by fire. B, that Shelby L. Shell started the fire intentionally, and C, that in doing so it was Shelby L. Shell's intention to damage or destroy the building, and D, that Ronnie King did not consent to the damage to the building, and E, in doing so, it was not Shelby L. Shell's sole intent to damage or destroy the building for a lawful purpose. Finally, the next page is the verdict form. We, the jury, agree by unanimous vote that Shelby L. Shell is not guilty of arson in the second degree under instruction 12, and we, the jury, the other option, we, the jury, agree by unanimous vote that Shelby L. Shell is guilty of arson in the second degree under instruction number 12. Again, the full person will sign on that. When you get through those instructions, you will tell the bailiff that you are ready to return your verdict to the court. The bailiff will be outside the door. at all times, and we will come in and you will deliver your verdict at that time. Now, I'll go ahead and say this now. You may take your notes back to, we're going to have closing arguments in a moment. You may take your notes back to the jury room with you, but they are not in any way to overrule the memories of the other jurors or your memory. It's your memories that count, all right? And at the end of the trial, we'll take up the pads from you. Now, before we...
Your Honor, can I approach real quick?
Sure.
I just want to put on the record that there's a heavy police presence here. There's 12 cops here. If the court would, maybe tell the jury that the people that are standing there are there to protect and make sure that the room is secure. I mean, I don't know. I just
don't know why they all showed up.
I don't know why we have so many police here. But
The Commonwealth didn't invite them. I don't know.
They're probably spectators.
and the fact that they're back behind, I think causes some prejudice, and I just want to put that on the record.
Well, this is an open courtroom. It's free and open to the
All
public
right,
if they
look,
pass.
have they been here the whole time?
No.
They just wandered in to watch it.
Well, they may have. I don't know. I'll just tell them not to hang out.
They probably should have said.
Be persuaded. All right, okay.
Thank
We pick the alternates now, or we want to do your arguments first? I guess
I
we do.
think we do the arguments.
Yeah,
right
okay,
now.
all right. All
What's
right.
that?
All right, just okay. All right, just okay. All right, just okay. Yeah, okay. Okay. Ladies and gentlemen, there's several law enforcement people around. Don't let that sway you in any way. I think perhaps a lot of people wandered in to observe the trial. So please don't be any of your decision making be swayed in that by any of that. Now, the instructions I just read to you are going to be the ones you're going by, because I made a few little notes to change it. And at the end of these instructions, I'm going to go ahead and sign them and date them right now. And they will be the instructions the court has indeed, in fact, and officially given to the jury for their deliberation in this phase. Let's see. 3:14. All right. So what I'm going to do at this point is, during closing, you can refer to instructions because I think council will probably refer to them during their closing arguments, and then we'll take them up before you deliberate, and I'll give you this one, give the bailiff this one for you to take back with you. And when you get back there, you'll select a foreperson and begin your deliberations. All right, Mr. Sonneman?
I'm gonna run yellow, so we need to pull this deep. I don't know how to turn that off.
It's on.
It's ready.
She'll
She'll
get it.
get on over there. There you go. Now. Yep.
You can look at the military.
He's right there. These lights will come out. Okay.
So is it like that?
How's that? From the magnified, you know the magnifier's on top.
The city's out.
It's all right.
Let me turn it off for now.
I'm gonna wanna refer to some of the exhibits, and I don't know where they're from.
They're over here to the left.
Well, exhibit, you need something up here.
Yes. I wrote down, it's exhibit 1 and maybe exhibit 2.
Your exhibits.
There's one or two. How many you need? You want to do one?
Yeah, 1, 2, 3.
Three with photos.
And I don't need them, but I need them to be accessible to be able to do that.
Okay. Photos. What do you have? You got to check it over.
This is 1 and 2. I'm sorry, Your Honor, I thought they were still out and we could get to it.
Photos right here.
What's your exhibit?
Have you on that card though?
I do this as well. So it goes.
Do you guys have exhibit 3?
Colin was exhibit 3 by chance.
Think with pictures, I think she married. Yes.
Got this part.
I was like,
Inundate them right now, and they will be